Hello, I'm Ricky Malik. Today I wanted to talk to you about waivers, specifically one type of waiver known as the 212H waiver. The reason I wanted to talk to you about this waiver is recently our firm had success with this waiver. Like we do with many other types of waivers, we needed to apply for this waiver before an immigration judge for one of our clients who was accused or alleged to be involved in some way as it relates to prostitution. Now, in order to qualify for this waiver, there are two aspects of this waiver, sometimes commonly known as the 15-year or the hardship. If a certain activity or crime occurred more than 15 years ago, and the Attorney General in his discretion, and when I say Attorney General in his discretion, it's not the Attorney General that will make this decision. The Attorney General through his subordinates and officers, and in this case, those are immigration judges. But it's when the Attorney General in his discretion through the immigration judge deems that the instance or occurrence occurred more than 15 years ago, that admission of this person would not be contrary to the interests of the United States, and there has been sufficient proof of rehabilitation. Then the immigration judge, the Attorney General, can grant this 212H waiver. Other than that, there's also another method to obtain a 212H waiver. And the second one is what we were able to succeed in for our client, and that is when you have to demonstrate that the individual has certain qualifying relatives, in this case a spouse or children who are either U.S. citizens or lawful permanent residents, and then that those qualifying relatives would suffer extreme hardship if this immigrant, our client, was not allowed to remain in the United States. Now, this may seem easier said than done. While I think most people think, well, extreme hardship, obviously, if a family member is deported, that's horrific, that's hardship. But in the world of immigration, you have to understand that immigration in general means the separation of families. So when one family member is, tragically as sometimes does happen, but is deported or ordered removed, then that's standard. That's not necessarily above and beyond the norm. What we have to show here is extreme hardship. Something more than just that the person will be missed or that they're needed financially. We have to show the emotional impact. What is it that is lost by the U.S. citizens or residents? It's not so much what will happen to the immigrant in terms of the hardship to the immigrant. It's more, what will the hardship be suffered by the U.S. citizen immediate relatives or the green card immediate relative family members. And you've got to show that using various factors. One of the big cases that kind of gives guidance to this is matter of Marin. While you want to show long duration of residence in the United States, other disqualifying factors or other criminal or negative behavior, and want to weigh them against positives, property ties, family ties, as I noted before, durational time in the United States, remorse and rehabilitation as it relates to the event or the issue at hand. And in this case, the prostitution, that this client of ours was no longer in any way related to or associated with any sort of nefarious activity, as well as the social impact, the stigma, the ostracism, everything that would go with breaking up this family, and why the closeness of this family was more dependent and reliant on this individual than maybe another family, to be able to demonstrate the higher level of extreme hardship. We were able to do this because the family had gone through a lot, mainly because of this case and the accusations, which we believe were not at all true, but were almost forced and goaded into this person essentially as often is the case with immigrants, being caught at the wrong place, wrong time. I mean, this happens a lot. You're stuck in that situation. You've got to get over it. And we were able to do that. And a lot of the many years that this family had been together, this issue had really caused them a lot of stress, caused them to break apart at times, and then come together in a much stronger way than ever before. And it was that kind of collapse and rebuilding is what we were able to use to demonstrate that now, if the family were to be torn apart again, it would be, and in the words of one of the family members, absolutely devastating and crippling. It was somewhat of a lengthy hearing. There was testimony, very emotional, by the client as well as family members and other witnesses. But in the end, the immigration judge did believe that the respondent, meaning our client, met the criteria to demonstrate that her family members that would qualify would indeed suffer extreme hardship if she was removed from the United States. The judge subsequently granted our client the 212H waiver, and in conjunction with that, we had filed an immediate relative petition, as well as the other documents or petitions needed for the adjustment of status, and then subsequently the immigration judge granted the adjustment of status, meaning that my client was a lawful permanent resident, a green card holder, upon the judge's ruling. And it was overall a very happy ending to a long and traumatic journey that this individual and family had to go through. Thank you very much. And if you know anyone or have any questions as it pertains to immigration, please do not hesitate to call the law offices of Ricky Malik. Thank you very much.